Welcome to another episode of the Attorney Lounge. I want to thank our guest today, Frank Ramos. He's a partner with Goldberg Segala. Frank, thanks for joining us here in the Attorney Lounge.
Thanks so much for having me.
We were just talking a little bit before we started and hit record here. Frank, you're like center of the fairway for exactly what this show is about. You're kind of known as the Miami Mentor. I don't know how you came up with that name, if that's a name somebody gave you or something you came up with yourself, but I think it kind of fits exactly the theme of the show and what we're going for. How did that name come up, I guess?
Well, I had created a personal website a few years ago. I think it was either pre-pandemic or around the pandemic, and I needed to have a name, and most of the names weren't available. So that's what I came up with.
Do you ever get online and do I've done that a few times where I get stuck in like the GoDaddy search, like what domain names are available and stuff. It's
Right.
always kind of interesting. Yeah. Well, it fits perfectly, I think, with what you do. So, and, I'm going to get into this, I guess, kind of later in the show. I want to start with kind of how you grew up, but I am curious, like what led to the Miami Mentor and kind of what led you to sort of putting some of the content that you put together online.
Yeah, I've been writing for Young Lawyers since I was a young lawyer back in 2001. I graduated law school in 97. And at the time, I was really writing more for myself than anybody else because, like many, I suffered from imposter syndrome. I didn't really know if I knew anything. I thought, well, let me put pen to paper and see if I actually know a thing or two about the practice. And so I started writing very simple, straightforward how-to type pieces for various local legal publications here in Miami.
Mm-hmm.
And a lot of that got wrapped into my first book, 2007, from law school litigator for the Florida bar. And then I didn't write another book until 2016, which was also directed to young lawyers, called The Associate's Handbook. And since then, I've done a lot of writing. I'm kind of taking a step back from writing books, but I've written a number of ebooks through various legal organizations. Almost all of them are free, and you can find them on my profile, either on my website or Miami Mentors website or on my LinkedIn profile page. And so it was just a way to put my thoughts on paper and then share it with a larger community.
Yeah, that's awesome. I think it's so helpful. And the fact that you just put it out there, a lot of your content is just available to anyone for free, I think is amazing and so helpful for a lot of young attorneys. I want to get into some of those things and some of those topics. I think first, though, I just tell us a little bit about your background, kind of where you grew up, went to school, ultimately kind of how you navigated into law in the first place.
Sure, I grew up in Chicago, and from a young age, I kind of thought of wanting to be a lawyer. And then our family moved down here, and I went to high school, college, and law school in Miami. And it was kind of a straight path. I don't think I really seriously entertained other career paths. At one point, I thought of wanting to be a fiction writer. At one point, I thought of getting into political management. But I think
Hmm.
law school was always sort of first on my list. And so I kind of went straight through a very sort of traditional path of going from high school to college, to law school, studying for the bar, and then taking a job.
Hmm.
During when I was in law school in '96 and I graduated in '97, that was a tough year to actually find work. It was one of those periods where there weren't that many law jobs available, and there have been several succeeding periods. Certainly, the period after the crash in 2008 for about 4 years it was very hard for pretty much any young lawyer to get
Mm-hmm.
jobs. So much so that law school sizes contracted significantly. But that was a tough time. But I ended up staying local. I ended up working for a national civil defense firm, then joined a boutique defense firm, worked there for about 26 years, and now I've moved back to sort of a larger firm at Goldberg Segala. I've been here at the time of this recording about 2.5 months or so.
Hmm. Well, yeah, because I saw that in your bio that you had been somewhere for about 26 years.
Right.
So talk about, if you would, a little bit like that transition and what that's been like coming to a new firm.
Yeah, I started at a big firm. I went to a smaller firm. I think my first firm had about 350 lawyers or so. That firm is now larger. The firm I moved to had about a dozen lawyers. That number's been kind of at that level for pretty much the entire time I was there.
Mm-hmm.
Great firm. At a smaller firm, when you're doing litigation, you end up doing lots of different practice areas unless you have a very niche practice. But for the most part, you're handling lots of different matters, and we were handling them primarily on the defense side, both through
Mm-hmm.
carriers and through self-insureds. And during the 26 years, I did pretty much everything A to Z. I did everything from asbestos to zoning and everything in between, litigation wise. So it was a great experience. I got to try different types of cases and handle lots of different matters. And then at one point, based on my sort of online footprint, if you want to call it that, through LinkedIn and other platforms, I was getting a lot of calls about matters that I couldn't personally handle and were getting referred out to other firms, which is great, great for the client, but I wasn't really appreciating any of that value. And
Hmm.
so somewhere along the line, I thought it would probably be best to move back to a larger firm. The firm I'm at now is in 10 states. They're continuing to grow and expand, and it allows me to reach out to people that would otherwise couldn't give me work, but may be able to give me work for one of my partners in another office to
Hmm.
handle.
Got it. Yeah. So did you? Yeah. I mean, what is that? I guess give me the pros and cons. I guess maybe for people out there, a lot of younger attorneys that are looking that watch the show, thinking about maybe going through. We're kind of coming up on the fall semester here. You're going to have a lot of second year students that are doing the interview process, and maybe they're trying to decide between a smaller firm and a larger firm. Like, any thoughts on kind of the pros and cons of those two types of firms?
You know, I don't know if so much the size drives it as it is the personalities leading the firm. And I think the biggest issue any lawyer starting out, either in law school or a young associate, is looking for is a good mentor, is a good firm that was really going to develop them not only professionally, but just personally, just in terms of their hard and soft skills. And you can find that at some small firms and I find it at other small firms. You can find it at some big firms and not other big firms. And I think the focus shouldn't be so much on the size um, as it is on how a given firm is going to develop you as an attorney. And there's some big firms that do it really well, and there's some small firms that do it really well. And I would, you know, the size of the firm, I think, is secondary to the culture of the firm and how much focus that firm puts on developing its talent. And if,
Yeah.
when you go into interviews, find out if they do have a formal or informal mentoring program, find out what they do to expose young lawyers to different opportunities, to get them in front of clients, to have them take depositions into their hearings and maybe second chair trial. And if you can find that at a big firm, that's great. If you can find that at a small firm, that's great. And that's really, I think, the primary focus. Those sort of questions are directed to how are they going to treat and develop you in your first 3 to 5 years.
Yeah, I think that's such a great point. The individual relationships that you develop with people along the way have such a huge impact on your career. And I was really lucky to have uh, some associates and some partners at the firm that I started with. It was kind of a mid-sized firm, Snell and Wilmer. It's a little bigger now, but they were great. And they allowed me to get my hands on some deals right away. My background was M&A and securities, um, and even though it was a bigger firm, I had they had a great mentoring program. I would say it wasn't even a formal mentoring program, but it was just a culture at the firm to develop young attorneys. And I've had a relationship with that firm now for my entire career, 26 years. Because I keep going back to them now. Once I moved in house, I still go back to them as a client and use them because those relationships are so strong. And so I think you're right. I mean, it's important to you know work with people that you like working with, and people that you're going to be working long hours with, and people that kind of look at their career and how successful they've been. And is that the kind of person or the kind of attorney that you see yourself being 20 years down the road? Um, so I think that's great advice. Um, uh, what types of cases, I guess, before we get into some of the Miami mentor stuff, I'm just curious, any interesting cases you've worked on that you want to highlight here, or, famous brushes with celebrities, or famous cases or interesting cases that you've been proud of?
Yeah, I don't know if I've had any big high profile cases, but I have had is a very unique and eclectic group of cases. I've handled eminent domain cases, tried those cases, have tried non-compete cases, have handled just personal injury auto case, have a trial coming up in auto matter. It's been a wide variety, asbestos to employment, everything else. And again, I guess that's probably one of the benefits of a small firm. If you're not quite sure what you want to do and you're looking at a firm that's a general practice firm, you're probably going to end up handling lots of different matters. And that
Hmm.
might be a good experience starting out because then you can try different things and see what you really have a proclivity toward. And I think some people like to pick a lane and stay in the lane, and there's lots of value add to that. But having handled, even trust in the state's litigation, I think I've handled some other things. You learn to pivot from one type of matter to the other. Things you learn in one type of case, you can kind of carry over into another in terms of hiring, retaining experts, in terms of how to present your case, developing themes and theories, how to take the complex and make it more simple and direct. So I think that's been a benefit that I've had, that now that I'm 52, I don't say I just handle this type of case. I can handle actually lots of different matters, and I think makes it a little bit easier to attract work and attract clients. Some people would argue just the opposite. People would say we should pick a lane, and everybody knows you're an expert in that lane, and if they have that need, then they'll give you a call. And I think there's truth on both those fronts, but my personal experience has been to do lots of different things over a long period of time, and it's
Hmm.
given me a lot of flexibility in what I can do now and into the future.
Yeah, it makes sense. Is there a part of the litigation process that you like better than others? I mean, I tend to think that most people are going to enjoy being in trial versus the kind of the grind of the discovery process and all that. But any particular sort of um, favorite parts of the job?
Yeah, I do enjoy trials. They're pretty exhausting, but they're a lot of fun. Taking depositions and just trying to use that as a basis to either move for subsequent dispositive motion or to strike an expert or to already think through how you're going to have a specific witness testify at trial. Sort of the high level thinking, thinking through the themes and theories of your case and then plotting it out and having a strategy from here to the end and back and kind of thinking through how all the pieces on the chessboard are going to move. That's actually a lot of fun too. And it doesn't really matter how complex or simple a case is, you still have to be able to tell a story and convince a fact finder that they should believe your story, not the other side. So some people may denigrate certain practice areas. Some people think certain practice areas are above others, but litigation to a degree is litigation, trials to a degree are trials. And at the end of the day, you have 6 people, you have to convince, or 12 people, depending on your jurisdiction, about your view of the matter, and being able to communicate with them effectively, having those soft skills of being able to share a story in a way that people believe you and want to see your side of the story, of being able to, convince a judge, being able to convince opposing counsel on a settlement, being able to assuage the concerns of a client. These are all sort of things that none of us really learn at law school, but these are all
Right.
very valuable skills to develop during the course of our careers.
Yeah. One of the things that, and you kind of touched on this a little bit earlier, but I always felt like the most effective teachers that I had in law school, undergrad, throughout my educational career, were the professors that could take a very difficult subject matter and boil it down and make it very easy to understand. I feel like that's probably true. I'm not a trial lawyer, so I'm not. I've never been in that position, but I would assume that the most effective trial lawyers are the ones that can take a complicated subject matter and really boil it down to something that's very easily understood. Do you find that to be like a strategy that you use?
Yeah, absolutely. I think when I first get my case early on, I'm trying to think of a case theme. And a theme could be a cliche, it could be a bullet point, it could be some sort of hook, really. It's like the hook of your case, like, that line in a song that becomes an earworm.
Hmm.
And you try different themes out during the course of discovery and see which one you think resonates and which ones really kind of fall flat. And so by
Hmm.
the time you get to trial, you have, a theme that you've tested during the course of the litigation that you feel is going to win the day. And the theme is something that's
Hmm.
simple. It's not that maybe a few words or a phrase, might be a song lyric or a line from a movie, or it could be a cliche like I mentioned, or some sort of sound bite that people can kind of gravitate toward immediately, and like, okay, this made sense, and it has to be something that's consistent with the facts, with the testimony, with the evidence. And if it is, if you can kind of encapsulate your entire story in a few words and then use those few words throughout the case and get witnesses to parrot the phrase or the cliche and put it in your exhibits and so forth. That's what the jury's going to be hearing. The
Mm-hmm.
redundancy of it, the repetitiveness of it when they get back to that jury room. You're hoping that they are articulating and stating your theme over and over again versus the other side. And I think ultimately, whatever side has the more resonant theme that really kind of is a through line for the case is ultimately probably going to be the winner of the case. However, whether it's on the type of work I do, it's, whether it's a verdict for the plaintiff or the defendant, if you're a criminal lawyer, whether, it's a guilty verdict or not. But I think all trial lawyers, no matter what we do, we try and come up with a theme and try to make that theme stick, kind of like the OJ Simpson, if it doesn't fit you must
Yeah.
acquit. That was something we're all going to remember. It's been, I don't know how many years later,
Mm-hmm.
and I'm sure those jurors in the back repeated that to themselves over and over again.
Yep.
And so if you can come up with that early in the case, I think some people, and especially people who are parachuted into a case, are trying to pick up all the pieces of the case and trying to figure out how to knit them together through a theme. But if you have a case from the beginning, my advice is always to start thinking very early what the case theme is going to be, and start putting and building a case around that theme.
I love that. And it gets very interesting when you start to think about that. You're taking massive amounts of information and data. You start to think about the themes. That was exactly when you were talking. That was exactly the one that was coming to my mind too. I think, like you say, it's 20 years later, and we still think of that case. If it doesn't fit, you must acquit. The other thing that I've heard you say a couple times too, that I think probably helps, is having a story, being able to tell a story. Um, people learn through storytelling, like Aesop's fables and things like that, like those themes that you come up with, and then being able to, you know, put them into a storyline of some kind that makes it relatable to people. I think, you know, I just, like, not being a trial attorney, but I think about the things that would resonate with me as a juror. Those are the types of things I think that would be impactful.
No, I agree. I think the movies or the books we read that stay with us, they generally have a very good plot, but the plot is just one level. Like they also have very memorable characters, and they definitely have a protagonist and an antagonist, and they're very memorable. There's underlying theme to that storyline, and it's all kind of tied together through that theme. And so, whatever side of the V you're on, you're trying to put your party as sort of the person who is the protagonist and trying to show the opposing party as the antagonist, even if they're the plaintiff, even if somehow they're the injured party. You got to find some way of deflecting the blame from yourself and direct it to somebody else. And if you can, if ultimately you have a case where the story clearly has a bullseye on your head, then that's a case you need to settle. Like, you can only do so much with certain things, and maybe your
Mm-hmm.
goal is to, like, limit the damages and not have the case be a runaway jury verdict. But you always want to tell a story, and the story starts with the characters, and you have to determine who your characters are. Who's your corporate representative, if you're the defendant, who's your plaintiff, who's, whoever it may be, and how do they come across? What do they say? How are they going to say it? How do they tell their story? And, are they going to be somebody that is credible and that is likable? I mean, again, going back to just basic, character analysis, when you look at a character and you put them or pigeonhole them in a certain category, do I trust them and do I like them? If I trust and
Mm-hmm.
like them, they're probably the protagonist. If I don't trust and dislike them, they're probably the antagonist.
Mm-hmm.
And so that's one line of demarcation where if the jury believes your client and likes your client, then you're well on your way home. And if they don't, then that's a problem.
Yeah.
And so we're always trying on each side to undermine the credibility and how the jury perceives and how much they like the other party.
Yep.
And there's different ways of doing that, obviously, but you're right. Telling the story through your character's perspective is eminently important.
Do you find do you approach different cases differently? Like, does your personality change, or are you always the same person, or do you sort of put on a costume, if you will, depending on a particular case, where you might be more aggressive in one case, or you might be more, you know, relaxed and relatable in another case. I think about it from the perspective of like depositions. I know some people are, very aggressive and they're just like hammering people like boom, 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 boom. And others are more like, just talk to me. Like, we're buds. Like, just explain this to me. Help me understand. Everybody has kind of a different sort of approach. Do you find that approach changing from case to case, or do you kind of have a consistent sort of personality and demeanor that you sort of carry into every case?
I'm pretty consistent, and it largely depends on who I'm deposing. If it's the opposing party, I'm entitled to lead them, so I'm going to shift between asking open-ended questions to get some background information to asking very directed leading questions to get the admissions I want. If it is a hostile witness, I'll do the same. I'll establish the fact that they're a hostile witness and then lead them into what I want. If they're an expert, obviously I can lead them.
Mm-hmm.
But if they're just an objective witness, you typically can't. The other side will object to that. So you have to find a different approach. It really kind of comes down to whether or not the witness has a dog in the fight. And if the witness is going to be inclined to say something that favors the other party, obviously if it's the other party, or if it's a family member, or if it's an expert, they're there to help them win the case. And so
Mm-hmm.
you want to establish bias early on, and then you want to also develop the fact of any admissions you can secure that you can later impeach them with if they're not being cooperative at trial. And I'm not argumentative, I'm not loud or boisterous, I'm not arguing with the witness. I don't think any of that's particularly effective. I'm just
Mm-hmm.
basically asking short questions that are in the active voice, that are one fact per question. I'm not using adverbs, I'm using few adjectives. I'm keeping my sentences, or questions, I should say, to about 10 words or less,
Mm-hmm.
so that there's no dispute as to what I'm asking. I think sometimes
Right.
attorneys ask very long-winded questions and they think they got an admission, but they really don't. And so finding a way to ask simple, direct questions and ask very basic facts and have each fact build upon the other, I think is a skill that is important to develop in any facet. And that's whether you're taking a deposition or going to trial or interviewing a witness, just being able to call out the facts in a way that helps your case, and doing it in a way that, it's not really argumentative. You're just basically asking one factual question after the next, and you get the witness to a certain point. And any witness, you'll be able to get them to agree with you up to a point, and then they won't. And that point may be reasonable and it may not be. And sometimes I'm as happy with an unreasonable witness as I am with a reasonable one. In
Mm-hmm.
fact, sometimes the reasonable witnesses are the worst because they do not come across as if they have an axe to grind or they're trying to prove a point. They're admitting things they should admit and pushing back on things they shouldn't.
Mm-hmm.
So sometimes, but if you have a witness, especially an opposing party or an expert who won't agree where the sun rises or where it sets, then you just lean into that. You get them
Yeah.
to fight you on every little thing, and it really makes them lose credibility. And again, going to credibility and likability, if I can get a witness to just fight me on every little thing, they're not going to come across as particularly credible. They may think that they've won because they haven't admitted to anything, but they've really
Mm-hmm.
lost in the eyes of the jury.
Yeah, I find that the best approach, it seems to me, is more of a relatable approach. The loud, boisterous, sort of gotcha type of attorneys, I don't find that to be a very effective strategy. It seems like getting people talking and being more, like you said, reasonable seems to be a better approach. One interesting thing I heard recently, like when you're coaching witnesses, when your side is going through the deposition, I heard recently somebody talk about that. They coach their witnesses that deposition is you're entirely on defense. You can't win the case. Don't try to win the case. Um, you know, all the sort of typical sort of stuff. Answer the question. Uh, don't provide more. Always be truthful. All this sort of stuff. But do you sort of have that same? There was some debate at the conference that I was at as to whether or not you could actually um, score points when you're being deposed. Do you have an opinion on that, or how do you advise your clients when it comes to being deposed.
I agree. I think I use the analogy of being a goalkeeper, where your job isn't to score on the other side's goal. Your job is to prevent them from scoring on your goal. You're not there to really win your case. I know it seems odd in deposition, but you're really there to not make an admission that is going to be problematic. Either it's going to serve as a basis for them to move for summary judgment or strike an expert or win some issue in a motion or a trial. And so I always made sure our clients or corporate representatives and so forth understand their role as a deponent is primarily to avoid making bad admissions.
Mm-hmm.
And then secondly, not to come across as unlikable, because again, those are the two issues. So,
Mm-hmm.
and you don't also like certain things you're going to have to admit, certain things are what they are. And like the example I use about disputing where the sun rises or sets, you can't have them do that. But for key issues where you you don't want them to just kind of cave, you don't want them to certainly not make admissions that aren't truthful. I mean, that's even more disastrous. But so that they understand what the question is asking, that they're only answering the question being asked, or they're not volunteering information, and they're not just simply agreeing with everything the interrogator is doing. Because
Mm-hmm.
it's easy if somebody gets into a rhythm of questioning, especially, I mean, my approach again is to ask very simple, basic questions, many of which are fairly innocuous. And and then at some point you start slipping in less innocuous questions. And if somebody's into that rhythm of saying yes, yes, yes,
Mm-hmm.
they may not realize that they said yes to a question they probably shouldn't have said
Yeah.
yes to.
Mm-hmm.
And that's an old method.
Yeah.
Basically, you ask them, where in a car accident case, you were driving that day and it was clear and it's sunny, right? And you were going X number speed, and there's nobody else in the vehicle, and you asked them a bunch of questions that no one really cares about, right? You're just kind of setting the
Right.
scene. But then at some point you slip the scene. It's like, oh, you weren't paying attention, or you had your phone on, and then and maybe you don't even ask that you weren't paying attention. You say, oh, and you had your phone in your lap, and you're
Right.
scrolling through the internet or whatever it is, and then you posted something on Facebook or Instagram,
Mm-hmm.
and that's a fact question, but like obviously the impression that you're being left is that person wasn't paying attention while they were driving.
Absolutely.
Um,
Yep.
so that's kind of how you do it. And then, and
Mm-hmm.
if on the other side, if you're defending your clients, like, well, they're going to ask you a lot of questions, some open-ended, some of them are more direct questions, leading questions. But you need to be aware that if they really start asking you a lot of leading questions, and even most of them sound kind of basic,
Mm-hmm.
at some point they're going to ask you a question that's really going to hurt our case. So, take 2 seconds before you ask each question. Don't fall into the rhythm of this
Yep.
quick back and forth where you're not giving yourself time to think about a question and you inadvertently say something, and then maybe you have to go back and fix it later in depot, which isn't great. Or maybe you forget about it altogether, and then after the transcript comes back, you're like, oh, I can't believe I said that. And I guess you can
Mm-hmm.
always correct the deposition, but then that opens you up to another depot. And so, being able to sit down with your client, go through a mock deposition line of questioning, maybe even taking your phone and recording them while you're doing that, especially if the depositions to be recorded, and showing them like, oh, you do this type of behavior, or you have these tells where it's clear you're not
Mm-hmm.
comfortable with the question. And if the other side is paying attention, they're going to realize that when you touch your chin or you adjust your glasses, it's your way of comforting yourself, and therefore you're not
Yep.
comfortable with answering that question. They're just going to dig in on that line of questioning, so you got to stop that.
Yep.
So
It's
those
kind
are
of
all
like
sorts of little things.
playing poker. You kind of have these little tells, and if you're picking up
Right.
on that stuff, I would, I've sat for a few depositions. I've been at 30B6 in a handful of depots, and I, I I find it very interesting, and and it's like a war of attrition. I mean, at the end of the day, I'm just completely exhausted because you're going through and trying to think about every single question, and I always try to take each question individually, and I always try to pause and think about what the question was before I answer. But it's hard to do when you get in. If somebody's, that's why I think like the more sort of boisterous, sort of antagonistic questioner is not as good as the person that's more monotone, relatable, and you don't even like they don't telegraph their pitch like it comes in from out of left field, almost like you said. Like you got 20 innocuous questions, and it's the 21st question when you're sort of tired and exhausted that is the one that like hits you, and you don't realize it till afterwards that they just asked you a question that's um, going to hurt your case. So,
Yeah, I
um,
always tell clients, and this is a hard habit to get into, and few of them actually do this, but well, I tell them two things. I tell them to always count to two in their head before answering a question, just taking a long pause.
mhm,
So that way it doesn't suggest to the interrogator that they're taking a pause in hard questions. That's a huge tell. But if you take a pause from the first question that they asked you what your name is to the very last question, then there's really no way to differentiate between whether they think it's a hard or easy question. It also gives you time to just, it makes it a habit. If you're only going to do
mhm,
that on hard questions, it's not a great way of doing it.
mhm,
And then I tell them also to answer the question with the question. If somebody asks you what your name is, you don't actually say just your name. You say, my name is this, or, what
mm,
time did you arrive at whatever scene? I arrived at the scene on time X. And
oh,
that kind of by doing that, it shows that you're answering that question as opposed to them
mhm,
later suggesting you answered something else. And it slows things down and it allows you to control sort of the dynamics because when I'm deposing the person, I'm always trying to drive the flow. And generally, I'm trying to be polite, but I'm trying to also be kind of quick. I kind of talk fast, I think fast, and I
mhm,
know that I already have a direction where I'm going with the questions. My outlines aren't, the questions aren't written out. They're generally by topic, and maybe some subtopics there where I may have specific questions asked. But typically, I know where I'm going with the line of questioning, and I'm depending on the answers I'm getting, and depending on how much pushback I'm getting, and depending on the admissions I'm getting, I'm either going to lean into or lean away from a certain approach. But all along, I'm going to do it at a fairly quick pace, not so
mhm,
fast the court reporter can't take it down, but fast enough that I disrupt the ability to think. I'm going to try to
mhm,
prevent the other side from doing the exact same things I would have told my own witness or client to do. Because if we're having that give and take, and it's very much a conversation, a very quick one, where you're not, one, I'm not being obnoxious, as you said, or boisterous. I'm having a very pleasant tone of voice, and I'm not trying to, be obnoxious. And I'm
mhm,
doing it quickly, and the person on the other side may just want to get this done. There's all these ways where I am gently nudging or pushing the deponent into answering questions in the manner I want them to answer them and makes them more likely to respond the way I want and more likely for them to give me a tell when they don't want to answer something. And then I know, like,
mhm,
okay, this is a jackpot. This is definitely an area where I'm getting certain vibes from this opponent, and they're clearly indicating to me that they're not comfortable with these questions. And so I'm
mhm.
really going to dig in here and in a polite way.
Yep.
I'm not going to actually telegraph the fact that I know that there's something going on, um, but I'm definitely going to do that. And
Yeah.
so that's all part and parcel of the approach when you take and depose people.
I love the strategy behind all of that. Do you record? Do you video record your depositions, or kind of what's your position on all that?
It depends. There's an additional expense, obviously.
Yeah.
Some people do that with all their depots. I understand why, because you can then later use it at mediation or a trial. There's really
Mm-hmm.
nothing like seeing a person and how they answer a question versus just reading a transcript. But it's not cheap. Even in Zoom days, you would thought the cost would have gone significantly down. It really hasn't. And
Mm-hmm.
so, if anything, it's gone up, which I don't really understand because most depositions these days are by Zoom. They just basically have to record the Zoom
Yep.
video. But nonetheless, it's if you're going to do that, you have to appreciate the cost. You got to talk to the client about it, obviously, and get their sign off and approval. And maybe there's certain depositions you want to do by video and others you don't,
Mm-hmm.
especially if you have a witness where maybe a cognitive issue is important or just how they come across. If you have a particularly cantankerous witness and you want the jury or the judge, if the bench trial to see how obnoxious they are, then, those are all sorts of things you have to, ooh, my lights went out here. I'm in a room here. But that's all sorts of things you have to do to consider.
Yeah.
And again, if you have a case where you're taking 10 depositions, you multiply that cost by 10 times, that's a significant amount.
Yeah. That makes sense. What about so I'm the general counsel for a e-discovery company. We also do depositions and all that sort of stuff too. But how do you or do you leverage e-discovery now as sort of a strategic advantage in any of your cases? I was talking to someone at another firm on another podcast and talking about kind of the strategic advantages that they can gain from sort of forensic discovery and this massive amount of data and sort of information that you can get today by using technology. um, do you leverage kind of AI, e-discovery, forensics to sort of get an advantage in any of your cases?
Yeah, for e-discovery, that's something you have to think through early on in the case. And e-discovery is kind of a double-edged sword because if there's going to be a lot of e-discovery, that is not inexpensive. And
Mm-hmm.
that's something the clients need to appreciate going into it. What is the cost going to be over the course of litigation? And do you want to fold that cost into an early settlement offer, or does it not matter?
Mm-hmm.
Because e-discovery can reveal all sorts of things in terms of text messages, emails, Slack messages, and there's pretty much a record of everything. We just don't really fully appreciate it, but there is some sort of
Mm-hmm.
paper trail for any communication that's ever been had in some way or another, and it's all on our phones or in our laptops or desktops, and getting that information can be a boon, but it can also be expensive. So that's an important analysis. And as to
Mm-hmm.
AI, I've been using the open platforms in a safe way. I don't input confidential proprietary information. I obviously test the output for any hallucinations, but I use them to prepare for every depo, for every direct or cross examination to help draft discovery. I'm not putting in any sort of HIPAA or personal or confidential
Right.
information into the prompts and open AI, ChatGPT-4, or any of the other ones, but I'm helping them brainstorm for me. Because if you think about how those platforms work and operate, they have taken the entire internet, scrubbed it, scraped it to every last post and podcast like this and video on YouTube and any information. And we lawyers are at a point in our careers and just the way we've evolved that we share everything. When I started in
Mm-hmm.
'97, first of all, the internet really wasn't there wasn't much there. There wasn't social media, there wasn't YouTube, there wasn't podcasts, there wasn't any of this. But also just the way we viewed our knowledge base was something to protect and to not share publicly. We only shared it with clients. We
Mm-hmm.
didn't share it liberally with other people. We don't want people to steal our expertise. And somewhere along the way between '97 and now, we share everything. I mean, I think
Yeah.
our whole model now is to give away our expertise for free through podcasts like this, through YouTube videos, through free CLE we just give away, through social
Mm-hmm.
media posts, through white papers, through materials on our websites. And it's our way of telling the world we're really good at this. And you can see we're really good at this because of the amount of detailed information we're sharing with you. Like, this isn't just your average, 5 points on how to do this. This is really above and beyond that.
Mm-hmm.
And whatever topic you pick, there are hundreds, if not thousands, of lawyers who have written, spoken, or shared a video on it. And each of these platforms, I mentioned ChatGPT 4.0, 5.0 is coming out soon. You have Claude 3.5 Sonnet. You have Perplexity of these others, Bing 1.5, Gemini 1.5, which used to be Bing. And you kind of go through these and they're all scraping the same data. I mean, they're using different algorithms, but
Mm-hmm.
so if you are getting ready for a doctor deposition, you are probably calling through data of hundreds of doctor deposition transcripts that are just sort of sitting out there, hundreds of hours of video on how to depose a doctor, both from the plaintiff and defense side. And these algorithms are then spitting out proposed questions to you, a theme for the depo, concepts or ideas for the depo, topics in the depo, and specific questions asked in the depo. And it's doing it in real time, so you can basically, put in a fairly detailed prompt with the follow-up prompts. Within 5 to 8 minutes, you have
No,
an
shoot.
outline of 500 to 600 questions. You just cut and paste, drop into a Word document, and then start, whittling it down or expounding upon it. And the depo prep that would have taken, I don't know, um, 3, maybe 4 hours is suddenly taking a lot less time.
A quick break here to thank our sponsor, Array, for making this podcast possible. The bottom line is if you're involved in a lawsuit, please reach out. Array handles the logistics for any litigation matter. They take care of forensic collection, e-discovery, managed review, record retrieval, court reporting. They even take care of legal staffing and recruiting, you name it. I'm a little biased because I'm the chief legal officer at Array, but I was also an Array client before I started working there, and they became my first call whenever I had to manage a litigation matter. Array handles all of the details of your lawsuit so you can focus on winning your case. Feel free to reach out to me directly or visit trustarray.com and we'll get you set up. Now, back to the pod. Well, we were talking about, how in today's day and age we share information online through all these, like you say, like podcasts, YouTube, social media. I mean, people are just so comfortable sharing their expertise where, you know, 20 years ago, people were trying to guard that information as their proprietary sort of strategic methods of sort of handling a case. Whereas today, like, people are very welcoming in terms of sharing information through different platforms and kind of how that has evolved and changed in the practice of law, and sort of your thoughts on that.
Yes, and I think that's a great opportunity for any lawyer, especially young lawyers trying to learn a new area or develop themselves in a new practice area. You can go to YouTube and learn anything. You can go to a podcast and learn any area of practice. You can go to firms' websites. There's just a innumerable amount of resources that weren't available when I started out that whatever area of practice I want to do, if it's negligent security, if it's data breach, if it's antitrust. I don't care how complicated the issue is. There are hundreds of free CLE on YouTube, and maybe they're not valid anymore because they're outside the window. I mean, you can't get CLE for them. But if you really want to learn an area, you can do that. I mean, I've become somewhat of an expert in AI, and I did that just by going online and reading and watching and listening to everything there was on AI.
Mm-hmm.
And there's a lot on it, and more of it is coming out every day. So the resources we have now as professionals is, it's unlimited, and there's really
Yep.
nothing that we can't teach ourselves through these various means and platforms.
Yeah, and it it kind of leads into another question that I wanted to ask you too. And we're kind of coming up, I guess, on time here. So you have a big social media presence. You have a large following on LinkedIn. We started talking about how you just started writing and sharing information. I mean, you have so much free content that is available online. Like, talk about, how that's, benefited your practice by being so willing to share and sort of, and how you've kind of gone about, utilizing social media to support your practice.
Yeah, I think when we give away content, we generally get some benefit back. And it's almost like we're creating a social contract with the larger audience where some subset of that audience feels indentured toward you because you've helped them out in some way by providing them some sort of information or advice or tips that helps them in their practice in one way or another. And they remember that. And at some point, if they have a matter or case in your neck of the woods, they're probably going to give you a call because they feel like they owe you something for that.
Mm-hmm.
And we can only handle so many cases. We can only have so many clients. So if you regularly post on social media and you're constantly and freely and generally giving away free content, even if a fraction of those people benefiting from it or reaching out to you, that's a lot. And so it is a great way of developing a practice by giving stuff away. And I see lawyers do this all the time. And again, there was a shift, I don't know when it happened, between hoarding all your data and information and knowledge and expertise and giving it away. But certainly in the last 3 to 5 years, I see lawyers who are expert on these platforms give everything away. They really are not hiding any secrets. There's no secret sauce. Whether they're great trial lawyers and learning about how they try cases, whether they're in a given practice area and telling you about all the top cases coming out or the regulations and so forth. If you follow that person long enough, you too are going to become an expert in that area. But they're doing that largely to show everybody I'm an expert in the area. And if you need something, give me a call and I'll be able to help you. And I think most
Mm-hmm.
lawyers who post frequently, maybe daily, over a long period of time, they have that commitment to it, ultimately see a reward coming from that. Just being able to consistently do something over time, I think is really the key to anything, whether it's diet or exercise or developing business. And so picking a platform, generally LinkedIn, posting on it regularly, preferably daily, on an area of your expertise, and doing it consistently over time is bound to pay off.
Yeah, yeah, and is LinkedIn kind of your primary social media outlet? I mean, I see you have like 75,000 followers on there. Obviously, you've got a pretty big presence there. Do you use any of the other outlets like Twitter, TikTok, Instagram, anything like that, or do you kind of focus exclusively on LinkedIn?
Yeah, I focus primarily on LinkedIn as the prospective clients I'm speaking to are on that platform. If I was a plaintiff's firm, or if I was a criminal defense lawyer, maybe a family lawyer or a bankruptcy lawyer, where my audience was generally individuals, they're probably not on LinkedIn. They're probably like on the platforms you suggested, on TikTok, on X or Twitter, on Instagram, and I would probably focus more on my attention on those platforms. I would probably, maybe
Mm-hmm.
do videos and do, ways where I'm speaking directly to them. And there are a number of colleagues of mine who are in all those spaces that are on those platforms and do a great job promoting themselves by giving away free content, but in a very different way than I do, in a way that's more personal and direct and sometimes comical and funny even, on these
Mm-hmm.
other platforms. And they have huge followings on those platforms, much bigger followings than
Yeah.
I have on LinkedIn. And they get calls that way, and I'm finding that
Mm-hmm.
even firms that haven't traditionally been in that space, if those are where the clients are, that's where they're going. So before you commit to a platform, you have to ask yourself, where's my client base? Where are they most likely to be when they're online? And again, if you're on the corporate side, if you're on the civil defense side, uh, LinkedIn is probably your best bet. But if you're representing individuals, these other platforms are probably preferable.
Yeah, that makes sense. And you see these different, like you still see, like even now, and maybe Arizona is different because I know they kind of changed the ethical rules where they allow non-lawyers to own law firms or have an ownership interest in law firms. And so, I mean, we see tons of, the traditional advertising still for personal injury firms like TV, billboards, all that sort of stuff. Um, but more and more, I think like the more sort of professional type uh, marketing efforts on these social media platforms like LinkedIn is becoming more and more prominent. Do you handle all that yourself? Like, and how much of your time does that take up to be posting on LinkedIn? Like, how do you sort of add that to your substantive practice area, I guess, to be responsible for that
Yeah, I
part of it?
do all my own posts, and I recommend if you're going to have like a personal page versus a website page for your firm or something, if it's just individual content, I recommend lawyers create their own content, just from purely ethical basis. You don't know what somebody may say
Yep.
and attach to your name, so you want to have total control over that. I think once you make it a habit, it becomes pretty easy. You can do it in 5 to 10 minutes once it becomes a habit. I tell most folks if you can post for 30 days, then on day 31 forward, it should be second nature. And a good way to
Mm-hmm.
start is to look at content you've generated in other contexts, maybe a PowerPoint slide deck. And if you have a slide deck that has 30 slides, that's probably 30 posts there. I mean, I started posting back in 2016, where I did like short excerpts from that book I mentioned. And I did that for like about a month or 2 months, and then I realized, why did I do something more than that? But by then I had gotten acclimated to going online every day and posting every day, and that became second nature. And then what I just had to roll into was now coming up with content. So I would determine what content you already have and cannibalize that content for the first month, maybe first 2 months, while you get used to just posting every day. And then at that
Mm-hmm.
point, you start generating your own just new content.
Mm-hmm.
And you can always go back to old content and repurposing it, but getting more and more habit of just coming up with new content and then make that a habit. And then once those two skill sets become a habit, one, doing the logistics of actually going online and posting, and two, coming up with content to post, it becomes pretty easy. And I think most
Yep.
folks, within a month or two, become second nature. These are short form posts. They're not, it used to have a 1,300 character limit on LinkedIn. Now it's 2,600 characters. But generally, I'm posting a few sentences. Maybe I'm posting something longer, but most of my posts aren't that long. And I've got to the
Mm-hmm.
point where I'm posting multiple times a day because I'm sharing content from other sources and so forth. And I'm
Mm-hmm.
not really spending a whole lot of time doing that. I'm just like, it's a thought comes to mind. because now I'm having 8 years into it. I have a lot of thoughts just pop in my head, and I'll go on my
Hmm.
phone, which is where I typically interact with LinkedIn on. And I think just download the apps for all these platforms on your phones. I think it's just easier to interact with them on your platform on your phone anyway. And then
Hmm.
I'll just type something up. Takes about 30, 45 seconds. I just proof it to make sure there's no um, mistypos or whatever, and then post it, and that's it. Um, and during the day, I'll reach out to people through the platform, through messaging. People reach out to me. I may interact with some comments. I don't generally do that. I just don't really have the time, but sometimes I interact with
Hmm.
comments. More likely than not, what I'll see is who's commenting and who's looking at my profile and who's doing all sorts of things, and I may reach out to them. And I have
Yep.
the LinkedIn special one. Like I don't have the free version, I have the paid version. There's different levels of paid version. I have like the
Premium, I
basic
think,
paid
or
version, yeah,
yeah.
the premium version, yeah.
Yep.
And since I'm as active as I am, I found it was useful. But I only got that maybe 2 years ago. So for 6 years, I wasn't using it, and I was growing my following. I don't really attribute the growth of my following based on the fact that I have premium. I just find that it gives me certain things. Like, for example, with premium, you get to see everybody who's been looking at your profile, which I think is a good data point to have. And there's some other
Yep.
features that I like about it. So
Yep, that makes sense. How much of I see like some of your content you talk about kind of imposter syndrome and some of that stuff. Like I feel like I myself I go through this up until my current position. I was the GC of a company. I had no need to be out in front and engaged and actively involved. I wasn't doing a lot of business development. In this role, I find myself doing more business development work and trying to promote our firm and stuff, which is, part of the reason that we started the podcast. But I find myself self editing before I want to post something and going, oh, that's going to sound stupid. Or somebody's already talked about that. They're not going to want to hear that from me. Or I'm going to post this and there's only going to be like one like. And then you're like, so you know what? I'm better off not doing it. And so with lawyers in particular being very risk averse and, thinking about all the sort of like here's all the bad things that could come from putting myself out there in the public. I like, how do you overcome that? Or how did you overcome that? I mean, now it seems like, like you say, a thought pops into your head and it takes a minute, you post it and you're out there. Like, do you even think about that anymore? And what advice do you have for people that may be self-editing and preventing themselves from putting themselves out there?
right, if you're very risk adverse and you're very concerned about the response you're getting on the platform, I'd strongly recommend you start with LinkedIn and maybe just stick with LinkedIn because a lot of the other platforms have lots of trolls and they have lots of people just taking shots at you. It can be kind of intimidating. That really happens in LinkedIn. I mean, in the 8 years, I've had a handful of people come after me, and I blocked them. And that was fine. But I mean, it's been pretty rare.
Mm-hmm.
And again, I don't post controversial things. I'm not there talking about politics or religion or just saying things just to get attention. I'm trying to
Mm-hmm.
be more uplifting and try to just show and share advice about career and maybe talk about some stuff about the practice and things like that. So the stuff I post is fairly non-controversial. I'm not garnering a lot of attacks in that respect. And yes, at first you're probably not going to get a lot of traction. You have to get a lot of likes or looks or views, whatever it's called, but it takes
Mm-hmm.
time. It takes a very long time and it's a long-term investment. And I tell
Mm-hmm.
people if you're going to start on LinkedIn or any platform, don't ever plan on stopping. And if you feel like you have a window or a trajectory where you're going to stop 6 months or a year, don't bother starting because I don't really see the point. Like,
Yep.
if you're going to pick up something like this, you're going to do it indefinitely. And absent, some valid reason for you to stop because maybe you change careers and you don't really, maybe your new company or firm doesn't want you doing that or something else happens. I don't know, or maybe you retire or something. But if you're going to commit to a platform, commit to it, and commit to it
Mm-hmm.
on a regular basis. It doesn't have to be daily, but it does have to be regular. And there's no horizon. There's no fading to black roll credits. This is something you're continue doing. And
Mm-hmm.
if you're going to continue doing it for 5, 10, 15, 20 years, at some point, you're going to turn the corner. You're going to basically hit the tipping point, uh, small at first and then bigger later on, where people are really going to follow you, like you, share your content. And it took me a long time. Like I'm now, like you mentioned, 70 some thousand followers. I want to say just in the last couple of years, it's really taken off.
Hmm.
So it
Interesting.
took me
Hmm.
6 years to really build that following. I want to say even in the last 6 months, like now when I say stuff, it really resonates with people because now I do have 70 some thousand followers and I've been doing this for 8 years. And I guess also partially because having done it so long, I don't really have that reticence anymore. So I just kind of freely share stuff, and I do it in sort of, in a very transparent, authentic way. So yes, it's going to take time, but if you stick with it, and this is true for anything, whatever you stick with, whatever approach you have toward marketing, um, unless you're completely screwing it up, if you stick with it, it's going to pay off eventually. If you are into speaking, speak. If you're into writing, write. If you're getting involved in organizations, do that. There's that quote from Hemingway, and I forget which novel, maybe For Whom the Bell Tolls or The Sun Also Rises, where someone was asked, how do you go bankrupt? And the quote was slowly at first and then all of a sudden. And that's kind of what it
Right.
is on social media. It's very
Hmm.
slow growth, very slow. And
Hmm.
and one day you post something, maybe it goes viral, and maybe something else goes viral a few months later, and suddenly you start
Hmm.
seeing people who pick up things. Like, for example, I think last week I had probably the largest views on a post I've ever done. It had 4.5 million views
Oh,
on a
wow.
post I did about. And if I remember, I'm trying to remember what the post was about, but it was basically about how at our firm, this was years ago at the firm I was at, there was an associate, and the associate felt like he needed to move on. The firm felt like he needed to move on, and he ended up taking another job. And then he came for me for advice, and I told him a few things. I basically told the most important thing I told them was like whatever happens here stays here, and wherever you go,
Hmm.
you get to define yourself again. And this is not a reflection on you. And there are 10,000 firms out there. And if you didn't work out here, it doesn't mean it won't work out for you somewhere else. I
Hmm.
think I said it much more articulately in both at the time and in the post. But
Hmm.
and I didn't think anything about the post. I just put it there, and I started noticing a lot of traction. And within a week, I had 4.5 million views, which for LinkedIn
Wow.
is a lot.
Yeah, that's huge. Yeah.
So and that obviously garnered a lot of people following me suddenly. But
Hmm.
yeah, periodically you'll have a post that goes viral. Maybe not like that, but goes viral. And suddenly you'll see a
Yep.
spike. And then suddenly you start seeing more and more posts getting more attention and getting more people looking at you a certain way. And so you just have to
Hmm.
stick it out. And if you have something to say and you really enjoy, like, first of all, you have to enjoy being on the platform. If you have something to say and you
Yep.
enjoy it, stick it out, and eventually it's going to pay off.
Yep. Yep. I've had one of the podcasts I did was with a friend of mine, an attorney at uh, Jackson Walker in Dallas, and he's became a sommelier. So he's kind of his
Oh,
day
okay.
job is an attorney, and then he's become a sommelier. He got all the licenses and all that sort of stuff. And he kind of had the same thing. He's become pretty big on Instagram, and it was like slow, very slow, but he was very consistent with his content. Kind of the same thing, like you said, like anything, like eating right, exercise, like any skill that you're going to try to master, learning how to play the guitar, you're going to start very, very slow, and then it's going to, once you kind of get the hang of things, then it starts to pick up later. And so, persistence, I've heard, is a big, consistent piece of advice that I've heard from a lot of people on doing social media. So, um, I think I'm going to have to wrap it up now. I think we've kind of hit the hour mark. Frank, this has been awesome, and I honestly, like, there's 20 topics I wanted to cover with you that we didn't even get to. So I hope that you can come back on another episode and we can dive deeper into some of those other topics. I love that you put your content out there. Highly recommend for anybody who's listening to this podcast to please go check out Frank. Follow him on LinkedIn. The content that you put out is great. It's uplifting. It's positive. I love that about it. Your website, miamimentor.com, is a great resource for aspiring attorneys, young attorneys, older attorneys, anyone who's involved in the law. So please check out his website, and just really appreciate you coming on the show.
Thanks for having me. It's been a great time.
All right. Thanks, everybody, for tuning in to the Attorney Lounge again, and thanks, Array, for sponsoring the podcast and making this all possible. And please like and subscribe and tune in for future episodes. Thanks, Frank. I appreciate it.
Thank you.